the matter of Darwall and another in Dartmoor National Park Authority.
Just give me 1 second, Mr. Stranger, if you will. Yes.
Yes. May it please the court, I appear with my learned friend Miss Sedgley for the Dartmoor National Park Authority. My learned friends Mr. Honey, Mr. Westway and Miss Stephanie Bruce Smith appear for the intervener, the Open Spaces Society. And my learned friend Mr. Moorhead appears on behalf of the respondents, who are the claimants below. My lords, I take as read the core bundle at the very least, and I suspect a whole load more has been read. And I want to start in this way, if I may, by drawing the court's attention to the fact that there are, when one crystallises the matter, two rival contentions as to the proper approach and meaning of Section 10 of the relevant Act. On the one hand, the Chancellor, along with the respondents, say that the permitted form of access exhausts the recreation that can be pursued.
Hang on. I mean, you want me to write that down. They say that...
Yes, I'm seeking to crystallise what is being said.
Yes, okay. That the permitted form of access, i.e. on foot or horseback, is that right?
Yes, that's the permitted form, and that exhausts the recreation that can be pursued. And that's because the only thing they say one can do is roam by foot or by horse. The position on the other side...
Sorry, I'm sorry, I've had a bit of technical glitch as I was writing down. He says the permitted form of access exhausts... Okay.
Exhausts the recreation...
Yeah,
I'm so sorry, my lord.
I can't concentrate on what you're saying because I can't get my notes up. This will be said to be an exemplar of why one should use a notebook.
Well, my lord, I'm offering no comment at all about how your lordship should proceed.
It could be a disastrous moment when my lord abandons technology.
It's truly problematic though, because I don't know what's happened. Yeah, and what's happened, I see. Okay, this is slightly problematic. It does actually make it quite difficult. Sorry, I have a rather established modus operandi, and that is being thrown into disarray. Right, he says that the permitted form of access is...
Permitted form of access exhausts...
Yes, exhausts.
Exhausts the recreation that can be pursued.
Yes.
Whereas we say that access to the commons is by a particular means, but for a purpose, that is to say, open air recreation.
Well, that's what the words say.
That's what the words say, and our case is that the words mean what the words say.
So the judge actually said that it was all about the right to roam.
Yes.
Where do the words right to roam come from in the legislation?
They don't. They don't come from the legislation at all. The legislation provides for a right of access by particular means for a particular purpose. And that's perfectly understandable when one contemplates that Dartmoor can receive in the course of any given year millions of visitors, and so one would rather have them come by foot or by horse than drive onto Dartmoor or some other way onto the moor. And I would respectfully suggest that when looking at the legislation, it's worth asking, having crystallised it in the way that I've just done, which is the more likely course to have been followed. The Chancellor's interpretation, supported today by the respondents, or that which the Park Authority placed before the court. And one has also to bear in mind that on the respondent's case, no form of camping can ever be classified as outdoor recreation. However inferior the tent may be, and however the anxiety may be to peer at the stars, no form of camping, on his case, can ever be outdoor recreation.
It's not outdoor, is it? Open air.
Open air, I beg your pardon, my lord. Could your lordships take, please, the Act itself, which is at volume 1 of the authorities' volumes, of which there are 3. But perhaps I should say, whilst we're turning that up, that what's envisaged by way of organisation at the bar is that this morning should be taken up by me and Mr. Honey, if your lordships are happy to hear Mr. Honey, and then this afternoon the reply to that, with my having an opportunity to reply right at the end. I
think you should try and give Mr. Moore's head 15 minutes before lunch, if you possibly can.
I will certainly endeavour to do that, because I was going to go on to say that I hope I would seek the indulgence of the court if I take less time than was otherwise predicted. And I've never known a court reject that proposition.
But this is a tricky and important case, Mr. Straker, so we do want to hear the argument.
Oh, yeah, most certainly, my lord. And I don't dissent from the point about the importance of it at all. I do say, ultimately, though, that it is straightforward on the terms of the legislation. Now, my lord, if your lordships...
At some point you're going to tell me, aren't you, what bylaw 6 means?
Yes, I will do that. I'll come to that, if I may. Bylaw 6, which is page 59 and 60 of the bundle. But can I first show the court the actual Act itself?
Yes. And
the actual Act itself begins at page 22, behind flag 3 of the first bundle of authorities. And there were at least two matters going on which were required to be resolved. The first matter was to deal with the commoners and a problem which had occurred, because of course they all stand in relation one to the other and to the landowners, was the fact that the old manorial courts had fallen into disuse, and so what was intended to be done was to constitute a Commoners' Council, as you see, page 22, from the long title, to constitute the Dartmoor Commoners' Council for the maintenance and the promotion of proper standards of livestock husbandry on the commons in and about the national park, and then to regulate.
Sorry. Where are you reading?
That is from the long title, page 22. It's the first page of the Dartmoor Commons Act. Just above the second hole punch.
For the purpose of conserving. Oh, I see. It's at page 23, is it?
22 in the hard copy is such a familiar problem with the hard copies.
They're taking a wrong page.
So
Yes.
which number, which of the recitals are you on about?
Well, I'm referring presently to the long title, which on my page is page 22, and I think my lord is telling me that
got it.
yeah.
Okay.
And your lordship will see that it constitutes, and this, as I said, was a first problem to be dealt with, the Commoners' Council for certain purposes, and then to regulate public access to the commons, so that was to be regulated, and then conferring powers on the council and the county council. And then one has, because this is private legislation, not a private member's bill as stated paragraph 34 of the Chancellor's judgment. This is a private bill promoted by the County of Devon, makes certain recitals, foot of page 22.
It's a private bill, which is a different thing from a private member's bill.
Yeah.
A private member's bill is a public act.
Absolutely,
Yeah.
absolutely. But in paragraph 34, it's put as a private member's bill. And one sees on page 23 further recitals dealing with the amount of land, dealing then with there being registered rights of common, and then the constitution of the council, and then it was regarded as expedient that the public be afforded a right of access to the commons as by this act provided. And if one just pauses there, it's access to the commons as by the act provided. And the access to is a consistent exercise within the legislation as to what is being done. And then your lordships see expedient about other provisions and objects can't be attained without the authority of Parliament. And then one has this referable to 239 of the Local Government Act 1972, and that provision was sent through to the court yesterday because the court will be alive to the fact that local authorities are ordinarily given power to promote bills, but have to do it in a particular way. And section 239, which, as I say, was sent through yesterday.
You don't know where it was put in the bundle?
I don't know where it was put in the bundle. I've been told it was sent electronically. We have spare paper copy, if that is...
My clerk did put some stuff in this morning, but obviously she tell me where she was putting it.
Yes. Well, can I pass up, or have passed up, a spare paper copy of 239 to your lordship? I'm taking it that it's just your lordship who would like a copy of 239 in paper.
I've got it.
I do have it.
Yes. Can I pass that up?
Do you have a spare?
Oh, do we have a spare? Yes, we do.
It's always a good idea if you're providing something to go in the bundle to say where it's to go.
Yes, exactly so.
So if those behind you just remember.
Yeah.
Thank you.
Yeah, but 239 is the position whereby you have a power to promote or oppose local or personal bills, and you have a circumstance whereby, would your lordships forgive me for one moment? Can you sort that out, please?
In the good old days, Mr. Straker, if your mobile phone had gone off, there would have been absolute chaos in the court. The judge would have gone ballistic.
Well, my lord, I'm so careful about it, so I can't understand that. Anyway, your lordships will see, having been slightly put off my stride, your lordships will see what has to happen in terms of promotion or opposition to local or personal bills. A resolution of a local authority to promote a bill shall be passed by a majority of the whole number of the members of the authority, that's 2392A. And then, in the case of promotion of a bill, confirmed by a like majority at a further such meeting convened in accordance with paragraph A. Now, the rationale behind my taking your lordships to this is because your lordships may have seen, although it's met with resistance from us, that there has been placed before the court some further evidence dealing with and putting forward extracts from Hansard in connection with this particular provision. And those are set out in the supplementary bundle, right at the end of it, the supplementary bundle. And I just want to touch upon it because I don't want to take up time in a side issue about this matter, but I am anxious that your lordship should be alive to the fact that the promotion of this bill was not as the respondents would have it, so that one has here a witness statement by Mr. Steen, 186 to 188, which deals with how he was the Member of Parliament who introduced the bill, and he records how he was working closely with David Macklin, amongst others, at DCC. We have in the material before the court the extracts from Hansard, which I think are in the final volume of the Volume of Authorities, Volume 3. Behind flag 43.
Why is this issue taken so long to come before the court or to be decided?
This particular issue about
wild camping, if that's what we're deciding. I
Well-
mean, the legislation was 1985.
legislation was 1985, and well, what happened was that matters proceeded in a perfectly comprehensible manner.
With bylaw 6 in place.
Yes, with bylaw 6 in place, which says, and your lordship wants to hear what bylaw 6 means, but your lordship see that. But what happened here was there was a consultation on amendments to the bylaws in the autumn of 2021, and
Where do we see that?
Core bundle, page 31, paragraph 6. And that was met by an assertion on the 1st of November 2021 by the respondent to this appeal that there was no right to camp, same reference, which then led to the High Court proceedings with the claim form being issued on the 8th of March 2022.
No, but what we don't know is what are the amendments that were proposed?
Were they to make it more liberal, more restrictive? What?
As far as those amendments are concerned, I've got no particular instructions immediately to bring to the court as far as those are concerned, but there were amendments which were being contemplated, if I can say this, as it would appear, in the ordinary course of events, as one might want to refresh bylaws from time to time.
Yeah, but what I'm asking, Mr. Straker, is a much more prosaic question. I don't understand why all of a sudden this comes to be the big issue it does, Does bylaw 6 allow camping or not on the commons?
The bylaw 6 does.
Does allow camping?
Yes.
Right, okay. And what was the change that brought this to a head and made us made all this case come to court and be?
Well, there was no particular change to the camping provision that was proposed. What caused this to come to a head was the assertion by the respondent that there is no right to camp, leading to proceedings.
Yes, but if bylaw 6 allows camping, which is what I think you told me, right?
Yes?
So what's being said by the claimant is that whatever bylaw 6 may say, the proper construction of the statute does not allow camping at all.
Yes.
Right. And so this is something new. So you would say, despite the fact that the argument, as I understand it, about traditional use for camping is not pursued, as I understand it, before us, you would say, as a matter of fact, was it? There was evidence that people did use Dartmoor and the Commons for camping.
Oh, absolutely.
Yeah. For years.
Is that right?
That's not accepted.
Oh.
No.
That's
The
not
evidence showed the exact opposite, that such camping as took place on Dartmoor, even after the Act, was contentious.
was contentious. But it did take
And,
place
and challenged.
and was challenged.
And was challenged, and the camper moved away.
I mean, what I'm afraid struggling with is I find bylaw 6 opaque as to what it actually said, and I'm not told what the changes are that were proposed, so I don't understand how you, Mr. Moorehead, or your clients were prompted to bring this case by the changes, because I haven't seen them. Where are they there?
I'm happy to do what I can to address that at this juncture, if that would be helpful.
Well, I
Wait
mean,
until
somebody needs to, because I just need to understand the context in which this comes to court.
the context is described in a statement that Mr. Darwall put in front of the court, which explains the increasing intensity of problem which has materialised in recent years.
Well, more people can be.
As a result of increasingly intensified use. My understanding is that with the promulgation of new draft bylaws, an opportunity was perceived to introduce fresh controls that would help to mitigate that issue and designate fresh areas where campers were definitely not to be admitted. And there was a falling out about how the power should be used, which led my clients to examine
When you say how the power should be used, i.e. the terms of the particular bylaws.
I put it that way because, and I don't at this stage want to get into the argument about what bylaw 6 means, but it's not accepted by me and wasn't accepted by the judge that it authorises anything. What it does is prohibit certain activities, certain
Criminalise.
I beg your pardon, Madam.
Criminalises.
Exactly so. It turns what would otherwise be a trespass into something that is potentially a criminal offence. So there's that nuance. But leaving that to one side, there was that opportunity to improve the quality of regulation over the commons, and there was a falling out over that.
But even this is rather fuzzy. What I'd assumed, but like my lord, I couldn't find out where it actually was there were plans to change the bylaws, that is clear, and your clients didn't like the changes. It wasn't clear to me whether it was because they were going to restrict wild camping, but not enough, or because they were going to purport to permit wild camping. But whatever their objection, they said, well, look, this isn't a matter of the bylaws at all, because there is Section 10 confers no right in the first place.
I think that's a reasonable characterisation.
Well, which was it? Can we not see the draft bylaws to which you object?
I'll see if we can find them. They were at one stage available I'm sure I must have a
You see,
copy
we've only
somewhere.
been given some of the evidence. I assumed that they were in one of the witness statements that was before the judge, but isn't before us.
I'm not sure that the draft was, in fact, but I'm pretty sure I did hand to the judge. I wouldn't wish to swear to it now, but I'm pretty sure I did hand him a copy of the proposed amended bylaws. He certainly saw, obviously, the bylaws which were then in force. But we'll do what we can to recover the draft which was then under debate. I don't want to interrupt my learned friend any longer than I already have. Really.
Just to interrupt you a moment longer. From what you were saying, it wasn't clear to me that the amendment said anything at all about camping. You said that they provided the occasion which led to your clients checking the law. Is it the case that the bylaws do say anything about camping, or are they just...
I would wish to check that,
Yes.
but my recollection of the trigger is as I have described it, rather than some particular form of words that was proposed in the draft bylaws. I will be corrected as and when I see the draft, but that's my recollection.
Thank you.
No doubt this matter can be tidied up, my lords, but my instructions are that the proposal by way of amendment, which might have been one of a number of proposals for the whole of the bylaws, was to narrow places where camping could take place. And that there had been camping before 1985, which was the question asked of me by the Master of the Rolls, is undoubted.
When you say camping, do you mean camping otherwise than on campsites?
Oh yes, I mean someone coming along and putting down effectively randomly a tent and sleeping in it overnight.
Yes, so that's what the phrase wild camping,
Yes.
I don't terribly like, but that's what it's wild camping effectively means camping otherwise than on a campsite.
That's right. It means that when you set off in the morning or in the afternoon, you don't know where you're going to pitch your
Well, that doesn't
tent.
follow. I mean, you could do wild camping, you may have decided I'm going to do it on that very field.
Oh, well, yes, you certainly don't know that you're going to be on a particular site. You might know you're going to be in a particular area or place, but you choose it at the, so to speak, last moment. There is another
You're
variant.
making that complicated, and that's really wrong. If I go out in the morning and I'm going to walk all day and sleep on the commons,
Yeah.
I may have decided in advance. I may know the area very well, or I may have used a map. I'm going to sleep in that field, and you know that from the moment you set out. But that's still wild camping if it's just a field. It's not a campsite.
Oh yes,
Is that
most
wild
certainly.
camping?
No, that's most certainly wild camping.
But that's why I
Yeah.
was disagreeing with your suggestion.
Yeah.
You haven't thought beforehand, where you just do it on the impulse of the moment.
No, it's just that there are variants of understanding of what wild camping amounts to, because some people assert that wild camping is simply turning up and putting your head down on the ground with a sleeping bag and nothing else at all.
Well, that's something we may have to explore
Yes.
later. But I just wanted to understand what the wild element meant. And I understood the wild meant otherwise than on a campsite. And if I'm wrong about that, I need to be
No,
correct.
you don't need to be. But what does need to be in mind is that we are concerned, so to speak, with camping, and the attachment of particular labels to it may not be necessarily the easiest way forward. But what we have to understand is that on my learned friend's case, he wants to say that every form of camping is necessarily bad as far as Dartmoor is concerned.
Well, not bad. It's got nothing to do with good or bad.
Oh, well, it's not,
He says not
not
allowed.
legitimate.
Yes.
Yeah.
Not within the term open air recreation.
Yeah, yes. He says
I mean,
that,
this is the simplest case, really. Is camping within open air recreation?
yeah, that's what it amounts to, but my
Well,
learned
is it?
friend says that if one approaches it that way, one's approaching the English of the section in the wrong way, because he says, and this is where one finds some difficulty as a matter of grammar in understanding what he is saying. He says that one's got two separate concepts there, one of which is simply to limit what can be done by way of when one has accessed the common, instead of being for the purpose of, as it describes. But in terms of my Lord's question, this is the simplest case, what does open air recreation mean? That point on open air recreation undoubtedly includes camping, and includes a vast array of other activities which one couldn't begin to list because it is endless.
Well, okay, but I mean, the case against you is it doesn't, because camping is a means of keeping oneself alive. You need to sleep, but you don't necessarily enjoy anything whilst you're asleep. So the recreation is the walking. I mean, that's what the judge said, not the camping. So, I mean, I quite understand that there are lots of things you can do in the open air, but there are two things said against you. One, camping's not normally in the open air because you pitch a tent, particularly on Dartmoor, where the weather can be quite rough. And secondly, you're not really recreating, you're just maintaining your human capabilities. I mean, that's
Yes.
said against you.
Yes, and as far as the first point is concerned, you're not in the open air. The question is whether the recreation is in the open air, and the recreation is camping. And there are innumerable recreations which are capable of being undertaken in the open air, where the person undertaking them may be completely covered in doing whatever it is, whether it's the fisherman by the bank sitting completely covered by one of those half-open tents, or whether it's the person who now, in exercise which is becoming increasingly popular, goes into some barrel-type arrangement and rolls down the hill. So you've got a vast array of exercises where you are doing something in the open air, which camping is, and which is also a recreation. And so,
Well, I mean, I hate to disagree with you, but you are going to have to argue this point. I mean, you can't just assume that because the tent is pitched in the open air. I mean, I understand that it's outside a building, a hard building, but I mean, I assume what's said against you is that a tent is not in the open air. I mean, the outside of the tent is in the open air and the inside of the tent is in the enclosed air.
yes, but the recreation which one is concerned with is the recreation of camping, and that happens in the open air, necessarily happens in the open air. The fact that the person camping receives some shelter from the elements by virtue of the tent which has been pitched and which provides the recreation is, in my respectful submission, neither here nor there, because one might as well complain of what people are wearing or the cover that they're taking in order to protect themselves from the elements. And the question is, what is the recreation? The recreation is camping. Where does that camping occur? And the answer to that is quite plainly that it occurs outdoors. Now, what I was doing, my Lord, was looking back at and looking at the 1985 Act. And can we go back there, please?
Just before you,
Of course.
you do, I think you were going to say something about Mr. Steen's evidence.
Oh, that's right. I was concerned about that, and I respectfully say that your Lordship shouldn't entertain it because it's perfectly plain that it's not going to the points which Pepper and Hart say should be gone to. If you could go back to the third volume of the Authorities at page 910, you will find yourself in the Hansard debate which is relied upon. And we have in the middle of it a suggestion that it would be good news if fox hunting occurred on Dartmoor without...
Sorry, did you say page 910?
Yes.
Oh, I see. Rather annoyingly, my bundle's got two sets of interpretation of this. So I found it.
But it's within a debate, and at 910, if your lordship has it, your lordship will see that in the middle of the page there's a passing reference to the desirability or otherwise of fox hunting. I'm not sure whether...
Well, sorry, I'm between the hole punches.
My honourable friend, the member for Ealing.
Yeah,
Yeah.
thank you.
And that's really a side, a passing reference. Obviously, it was contemplated that might be within the scope of recreational activity. But look down, if you don't mind, at the foot of the page.
So what did you say? It's contemplated that it may be within the scope of recreational activity.
Well, yes,
Fair
we looked at it,
recreation.
my lord. He's been helpful in the House. One hardly dares mention fox hunting, but I believe if ever a place was suitable, it's Dartmoor, no question about it.
This is Sir Peter Mills speaking.
Yes. But the real point on this page goes at the foot of it, 910. I wish at the outset to pay tribute to the industry, tact and capacity for listening and decision-making shown by my honourable friend, the member for South Hams, Mr. Steen. He's borne the burden of the bill, not only in Parliament, but in the immense amount of work outside, working closely with a gifted parliamentary agent. That's misspelt, actually. It should be D-U-K-I-N, Mr. Joe Durkin, who was then with Recent Freers, who has been handling the bill on this occasion. And the clerk to the County Council, who would be there the County Secretary and Solicitor, Mr. Macklin, who's the Chief Executive, and his staff. And so we have the circumstance where it is said that Mr. Steen can be taken as being the promoter of it, the bill, because he's been speaking to Mr. Macklin, the Chief Executive, whereas it's perfectly clear how the arrangements for the promotion of the bill were pursued, the way given by the Local Government Act, with then instructions to Mr. Joe Durkin to pursue the matter, and so that one can't, with the greatest respect, assign to Mr. Steen the label of promoter of the bill sufficient to bring into play the pepper and heart requirements.
That rather depends what's meant in pepper and heart by the word promoter. Obviously, pepper and heart, they were thinking about public general bills,
Yes.
where the promoter is a government department and the promoter is the minister for that department. In a private bill, the situation is rather different. The actual promoter is not a minister, not anyone to do it. It's a private person, in this case, a county council. But what is said against you is that there has to be an MP who takes responsibility for its passage through the Commons, and they'd have someone else in the Lords, and they are the promoters for the purpose of the relevant principle. That seems perfectly reasonable to me.
Well, they are described as introducing the bill to the House, and the...
Yes, but isn't that include being a promoter in the sense in which Lord Brown Wilkinson used that phrase in Pepper and Heart, given that he wasn't actually contemplating the situation?
I mean, Pepper and Heart, as your lordship points out, says absolutely nothing about private bill legislation.
Yes, but the spirit of it is that the person responsible says to the House when they're passing out, this is what this means. I would have thought that an MP in the position of Mr. Steen, who is the MP responsible for shepherding it through the House, though not the promoter in your sense, would have a similar rationale behind allowing what he told the House to be admissible. Anyway, that's what I understood was how Mr. Morshead put it, but if I've got that wrong...
Well, that's how he puts it,
Well,
but
what's wrong?
It's wrong because Mr. Steen is simply the person who introduces it. Ordinarily, when one has private legislation, the Chairman of Ways and Means will introduce the legislation, but the promotion and the promoters are distinctly the Devon County Council, and one can't assign to the person who is asked, please would you introduce this bill to the floor of the House, the knowledge and desires of the promoters, so as to say he is equivalent to the minister whose ministerial department is promoting the piece of legislation.
I don't want to argue the point wasn't necessary, but it's not about their knowledge and desires. It's about what the House was told. It's relevant to what the House understood the bill to mean.
Well, certainly it's bears on that, and as to that, of course, there's nothing, no reference at all, save one or two passing references to recreation, to say that there was any discussion of the purpose, the language, which had been.
Well, that's a different point.
Yeah,
but I
it
want
is
to
a
take a
different
point
point.
about the status of Mr. Steen.
Yeah.
But I've said what I want to put you.
Yeah, but I respectfully say, if I may, that one has to be somewhat cautious about extending Pepper and Hart to the sort of circumstance that your Lordship and I have just been discussing, because the role of the person who introduces can't be, I say, equated to that of the promoter, and for good reason. They're given different names. That was a detour because of the evidence which has been put in. Can we go back, please, to section 10? And what I particularly want to do is to look at section 10, and then I also want to show the court some references to open-air recreation. Now, section 10 itself is on page 035 of the first bundle of authorities. And your Lordships will see that one sees and notes that access to, which we saw in the recycles, is carried across, fourth line, access to the commons on foot and on horseback. And then one has an express purpose being given as to why one might access the commons on foot and on horseback. Geographically, it might be possible to access Dartmoor by river. The River Dart runs either adjacent to or through, but that wasn't provided for, and one contemplates in that aspect. The learned friend would then say that the recreation was the boating rather than the access to the commons. And then one has the clause after the semicolon that a person who enters on the commons for that purpose, that is to say the purpose of open-air recreation, because that is the purpose described, without breaking, etc., or is on the commons for that purpose, having so entered, shall not be treated as a trespasser. And so one sees there clearly the language that one's got access to for a purpose, and they're treated differently in that proviso, which prevents, so long as one's behaving oneself, one from being treated as a trespasser. And we have then in the section some provisions which touch first on the Occupiers Liability Act, and then which introduce certain provisions from the 1949 Act, which is the National Parks Act of 1949, and I don't need at the moment to say any more about that. And then one has...
except that it introduces Schedule 2, which is exceptions, isn't it?
That's right, because what happens, and these provisions, 65B to G, 66, 68 and 78, what they effectively say is that we can have excluded places within the area to which otherwise one has access. And so that it might include mineral operations, it might include a house, or it might include other such matters. Now, if one looks on, one sees that nothing, subsection 4, prejudices or affects the exercise of powers under any enactment whereby access to the commons may be regulated or prohibited, and by notices posted on the commons as the Park Authority think fit, they may regulate by all or any part of the public to any part of the commons, including any footpath or bridleway thereon, for the protection so far as is reasonably necessary of a number of matters.
The principal such enactment is presumably the 1949 Act. There might be others.
1949 Act?
Yes.
Yes. But the point here to be made is that you have this regulation which is enabled to be made, just as you have bylaws able to be made. Section 11, 037, whereby you can then regulate the way in which the open air recreation can be conducted, so that you might, for example, if an area of land has become overused by people using it for throwing a cricket ball about or kicking a football about or whatever it may be, effectively protect that area while it recovers, and the footballers would have to go elsewhere. And the bylaws, which are given by section 11, are supplemented, of course, by section 13 and section 14, 038, section 13, the Park Authority can take such steps for the protection of the commons against unlawful interference as could be taken by an owner. And where a member of the public enters upon the commons for the purpose of open air recreation on foot or on horseback and causes damage to the commons or anything therein, the Park Authority may make good that damage. And the bylaws, which my Lord the Master of the Rolls expressed an interest in terms of particularly 6, and whether it permits camping, the starting point is that the legislation provides access for the purpose of open air recreation, and then camping is regulated by 059.6. Can't have anything other than a tent in certain areas, and you're not allowed to camp in a tent on the same site on the access land for more than 2 consecutive nights.
What's the definition of access land?
The access land is defined at the paragraph 1, there are 2 Roman, yes, paragraph 1, access land shall be all that land defined as the commons.
Sorry, paragraph 1 of what?
058 bylaws.
Bylaws, yeah.
All that land, access land, is defined as the commons in section 2 of the Dartmoor Commons Act, and land within the Dartmoor National Park to which they have access by virtue of the authority having interest in that land, and which is more particularly identified in Schedule 1 to these bylaws. Now, what I'd like to do now, if I may, is to switch
Sorry,
tracks.
I just wanted to be quite clear about, I've now understood bylaw 6. So it says you can't use a caravan or any other structure except a tent for camping on the access land. You say necessary implication, you can use a tent for access, camping on the access land, or on a designated car park, except if the area has been, it says caravans can park here. That's 1, is that right?
Yes.
And then 2 says no person shall knowingly erect a tent on the access land. So it's a limitation of the implied right given by or
Yes.
recognised in 1. in any area listed in Schedule 2 to these bylaws. Do we
Yes.
have Schedule 2?
To the bylaws.
We do, I think.
Yes, I believe it begins, wait a minute, at page 064.
Yes, I see. And
So you see it.
and it starts additional areas where camping is prohibited.
Yeah, that's right.
And we can assume, otherwise we wouldn't all be here, that it doesn't cover all, or I suspect much, of the areas in which the commoners have an interest, or the owners have an interest, I should say.
The owners, yes, the respondents.
Yes.
Yes.
But do we know Schedule 2 is what areas you thought to be particularly sensitive, or we don't know what criteria are applied in putting something on Schedule 2?
Well, it would be a variety of criteria, and I haven't got, and I don't think...
No, I just wanted to get some sort of feel for it. But it's obviously a small number of specific sites.
Yes.
Chosen for some reason that we don't know.
Yeah, well, it's chosen
Yes.
obviously, and principally probably for environmental reasons.
Yeah.
There's
Okay,
shown,
thank you.
it might be proximity to a river, the River Plym is mentioned, and proximity to a bridge or something of that sort.
And again, and then 3 is you can only just camp for one night in one place.
Yeah, but what it shows is the working out of the legislation and the bylaws so as to enable camping.
Yes, sorry, I'm just still on the wording. Sorry if I'm way behind everyone else. 3, no person shall camp in a tent on the same site. That's capable of being ambiguous. That doesn't mean a campsite, or in context, that just means a place, location. Yep.
Yes, that's right. So
Yeah, just you don't need to say. I mean, if that's right, that's enough.
no, that is absolutely right. And there's been an exchange already as to, well, when you are camping, so to speak, you're doing something other than indulging in a recreation, and you are there, but that precludes someone staying in the same place, because I readily acknowledge that you can have a campsite or a camp where someone lives, and not for recreation purposes. I readily acknowledge that you might have a military camp, which when the military are there on manoeuvres, but you've got a range of activities, and camping has always been identified as being an open-air recreation. And I respectfully say it would be an entire misuse of English to say that it's not an open-air recreation.
Without prejudging that, do you say that this bylaw, which was introduced presumably immediately after the 1985 Act, presupposes that camping is generally permitted under the Act and just regulates certain areas where they say it's not permitted? I mean, it's explicit in that regard, right?
Yeah, absolutely, and that's what it does.
So why did the judge say why that was wrong?
Well, the judge said...
I mean, it may not be obviously a determinative of the proper statutory construction, but it's an indicative indication at the time that this act for which bylaws are made seems to be understood by those making the bylaws at least to allow camping.
Yes, that's absolutely right. And
is that not a big point? I mean, nobody seems to make it.
oh, it is made, certainly, and I would readily say, I mean, what adjective one attaches to it in terms of its size, I leave over in effect, but it's a valuable point to have in mind, and it can be noted particularly in relation to the Malvern Hills Act, which is drafted in exactly the same terms as...
How can the Malvern Hills Act be relevant? It's a different statute, later.
It's a later statute.
So, end of story.
Well, yes, but if I'm pursuing the line mentioned by the Master of the Rolls that one can have contemporaneous exposition effectively through bylaws indicating this, we've got legislation taken for the Malvern Hills in the same form as Dartmoor, and then immediately the bylaws are made for the Morven Hills to say no camping on the Morven Hills, full stop. And so we have that treated in exactly the same way in circumstances whereby if access on foot or by horse exhausts the form of recreation, you would not need to have that.
Can I just understand, my lord asked you why the judge appears to have said something different. What I understood the judge to have based his position on is this, that generally on Dartmoor, access is through access agreements. Yes, is that right?
At least on part of Dartmoor.
Okay, part of Dartmoor. And the evidence was that on those access agreements, it was standard to exclude the right to camp. Have I got that right? So
Well,
if you were right, there would be a difference between what was happening in the Commons area, the area covered by the 1985 Act, and the access agreements and the position under the access agreements generally.
well, there could be some form of difference between those two areas.
But that is what the judge was saying, isn't it? Or have I
Well, no, I wouldn't,
Okay.
with the greatest respect, say that's how the judge was approaching the matter, because the judge was approaching the matter on the basis of the legislation, section 10, only enables access for the purpose of roaming by foot or on horseback. That's the purpose.
Yes, that's the conclusion he came to.
That's the conclusion, that's the purpose.
Well, I don't want to slow you down, but I just wanted to bottom out why there, notwithstanding what the bylaw clearly appears to say, there may well have been a practice on most of Dartmoor of camping not being permitted because it wasn't allowed by the access agreements, in which case it wouldn't matter that it wasn't contrary to the bylaws. It would be prohibited as between the, it would be prohibited under the terms of the access agreement.
Yes.
If I've misunderstood it, tell me.
No, well, it may be that there are access agreements which prohibits camping by virtue of the agreements which have been made, but we, I respectfully say, my lord, don't have to concern ourselves with that, because we're simply concerned with this part of Dartmoor, the bit being provided for by the legislation, and the terms of the Act saying you can have access for the purpose of open-air recreation.
Sorry to slow you up again. Mr. Morshead said, well, that the purpose of the bylaw may be just to criminalise certain conduct, and it is indeed the case that a penalty is attached to these particular specified activities. I don't, I'm afraid, remember where the judge deals with this. Are you able to remind me of
Yes.
that?
The answer to that question is not straight away, can I remind
No,
you?
well,
but-
don't get distracted.
Yes. Well, but he does, towards, I think, the end of his judgment, refer to it, and I'm not sure that he places very much weight on that particular aspect. But perhaps I can come to that. Could we next just have a moment to look at the National Parks and Access to the Countryside Act of 1949, which is behind flag 2. And here you will see that at 006, this was an act to make provision for national parks, confer certain powers, and for securing access to open country, and to amend the laws relating to rights of way. I don't need to read on. And then, if you look on section 59, O12, provision for public access to open country. The provisions of this part of this Act shall have effect for enabling the public to have access for open air recreation.
Sorry to be a nuisance. This is this very tiresome way of printing stuff off the internet. This doesn't show you which part this is. But I think if you look at the bottom, instead of where you'd expect at the top, this is the first provision under Part 5. Is that right?
Yes, let me just double check that.
Yes, 59 is the first
Yes.
in Part 5.
Thank you.
Provision for public access to open country. And I can pass over section 60 because I want to show you section 114, the interpretation provision. Open air recreation, section 114, does not include organised games.
Sorry, just what? That's not 60. That's what. Can we just pause on 60 before we go to 114? So this is, as you would obviously point out, the same language exactly as section 10.1.
Yeah.
Except that it doesn't apply generally to the park. It applies to areas where an access agreement or order is in force.
That's right. That's right. That's right.
So that's a rather different context, because
It's a
section
different-
10 applies to the Commons generally and takes away, as it were, the right to negotiate an access agreement.
Yeah, it's a different way of achieving an object, and it was bearing in mind the circumstance, well, we're dealing with a desirable end, the public having access to open countryside for the purpose of open air recreation. But we've also got, on the other side of the coin, we've got private rights of ownership we've got to deal with. How are we going to deal with that? And this is the mechanism which is there chosen to deal with that. But what this does help us with is, what on earth does open air recreation mean? Because section 114 tells us that open air recreation doesn't include organised games. So in other words, but for section 114, open air recreation would include 2 football clubs organising to play their fixtures on this given parcel of land subject to this right. And that is important in my respectful submission when one bears in mind that we've got, as I say, these 2 concepts being put forward. One, the recreational right being exhausted by the means of access. In other words, all you can do is walk or ride your horse. Or you access in a particular way, and then you can do what you like, but in the context of the National Parks and Access to Countryside Act, that won't include organised games.
Is it your position, therefore, that since there isn't an equivalent to section 114 in the 1985 Act, is there?
That's right.
So the result would be, if you're on your construction, that the 2 football clubs could arrange organised sports on any part of the commons.
Yeah, and you would preclude that by the regulations and the bylaws that you put in place.
Is there such a bylaw, out of curiosity?
I think there is. I'm not entirely sure. I'll have to come back to you on that. But that's how you would do it. But the point is that what one is being shown by this legislation is that when one is thinking about open air recreation, you have to think about all the sorts of things that people do out of doors, open air recreation. And my learned friend says, well, all you can do is ride your horse by way of roaming or walk about by way of roaming. And
if you look at the bylaw, Mr. Straker, things you're not allowed to do under this bylaw is drive a motor vehicle under 3, or use a motor vehicle, park 4, repair vehicles, camp in some places. Don't think the water one matters. Light a fire. Can't do that. You've got to keep your dog under control. You can't feed people's animals. You can't exercise racehorses. You can't hunt, shoot, or fish. And you can't shoot, discharge any projectiles. You can't damage the land. You can't do metal detecting. You can't sell things, do commercial activity. You can't land a plane. And you can't fly a kite or a model aircraft. And you can't hold a show, concert, exhibition, or other entertainment. And you can't play a radio or play music. Now, and you can't obstruct rangers. So somebody's given quite careful thought to what you can't do.
Oh, yes, and
So you probably can. Presumably you can have a football match there.
well, it may be that you could. The Exeter locals could play the Plymouth whatever. But
So do you say, I'm sorry to just delay you still further, but do you say that all these things would otherwise be open air recreation?
well, I haven't considered that particular question as to whether or not operating a musical instrument, I'm looking at number 20, is an open air recreation. So I haven't considered that particular matter. I certainly would not, in answer to your Lordship's question, which is put in comprehensive terms, would I say all of these matters are within the scope of that. I certainly wouldn't wish to answer it in those terms given. It may well be that some of them are, but what it shows is that, as your Lordship has pointed out, that careful thought has been given to what is permitted to occur on the land to which people have access.
Just in terms of organised games, I dare say it's unreal to suppose that any established football club is going to choose to set out on foot or by horseback to play a match in the middle of moorland. If, on the other hand, 10 people set out with some jumpers they were going to set up as goalposts and play five-a-side football, you would say that was open-air recreation.
Yeah, and not an organised game. So that one.
Well, it is an organised game.
Well, I mean, every game is organised in the sense of when one's arrived and said, shall we have a kickabout? There was plainly going to be a boundary somewhere between organised games which are prohibited and those which are not. But if half a dozen youngsters turn up, whether with a cricket bat and stumps or with a football, and say, shall we have a kickabout? I would say, well, that's not going to be an organised game, even though the position may be one whereby they start to say to themselves, you've scored 20, I've scored 15, you're winning, etc., and put a bit of
In a sense,
organisation.
it's irrelevant whether it's organised game, because we're agreed that 114 doesn't apply under the
Yeah.
1985 Act. The real question is it outdoor recreation?
Yeah,
And
but,
even if it's quite highly organised, if
Yes.
they say, let's meet at 10 o'clock at the top of such and such tor and have a game of cricket, and you bring the stumps, and we'll play between 10 o'clock and 5 o'clock, and we'll have a break for lunch in the middle. That's organised, but they can do that.
yeah, and remember, my lord, that my learned friend would say, no, you cannot do that. That is impermissible here. You cannot
Yes,
do
he
that.
may be right, mightn't he?
No, he's completely wrong.
Well, but you're saying that as if he was as if that showed the argument was wrong, but I'm not sure it does show the argument was wrong, that you can't do that.
Well, his argument depends upon the proposition that you are limited by way of your recreational activity to roaming. That's what his argument depends upon. And he says, amongst other things, that the argument from the Park Authority, just give the words the natural meaning, is wrong, because he says, amongst other things, that that would mean that somebody would have a better use of Dartmoor than somebody else. Take the cricketer who puts in the stumps. If you then arrive, you're going to walk around that rather than knock down the stumps, you're going to take notice of that. This is just part of the give and take of ordinary life, of course. But it doesn't mean that his argument about only horseback and only walking around for roaming obtains. It's just because on his basis, you would, at winter time, have to say that nobody could toboggan on Dartmoor, and nobody could walk onto Dartmoor, the family with the child heaving some toboggan would not be able to use it because they don't want to go roaming. The last thing they want to do is roam. They simply want to go up to a high bit and put the child on the toboggan and say, go down and enjoy yourself. And my learned friend would say, no, you cannot do that.
Are you leaving section 60? Or are you coming back to section 60?
No, I think I can probably leave.
I mean, in terms of section 60, there's a structural difference about access agreement or order. There has to be an access agreement or order. The latter part is very close to what we then get in section 10. But there is a structural difference in that section 10 includes the words on foot and on horseback, and that has an implication, as far as I can see, for how it's drafted. Does one get anything out of the similarities, anything out of the differences, or not really?
Not really, because the principal point here is always going to take us back to section 10 and what do those words mean, and then the question posed by the Master of the Rolls, what does open air recreation mean? As to which, the position is one whereby if one looks, if I may invite the court to do this, at our skeleton argument, core bundle 017, I think this will be. At paragraph 14, I reference Credit Suisse against Alderdale, which you have, and I'm just going for present purposes to refer to it in this text, having an eye to the clock. Lord Justice Neal cites with approval Mr. Justice Coleman's judgment, in which he said, those who go on camping pursue the recreational activity of camping. Camping is an occupation, pastime, or amusement. And that's how recreation...
I don't want to be taken to the case. What was the context? What was the issue to which that went?
Oh, well, the issue that went to was there was a big debate because it was all to do with local government finance. Mm-hmm. And the local authority had been trying to finance some timeshare accommodation. And so sort of distinctions were being drawn as to whether or not that was going to be something which could be labelled recreational for the purpose of salvation of the financial deal which had been made. And so there, the question of camping emerged, in which the judgment referred to that as a recreational activity, and the Court of Appeal...
okay, you've told me what the context is.
Yeah.
Okay. Before you leave this point, if you go to Mr. Honey's skeleton at paragraph 44, if you've got that, you'll see in the second sentence, he says a recreation is an activity or pastime pursued for the pleasure or interest it gives. And while that's not attributed, I think it comes from the Oxford English Dictionary. And indeed, in the authorities bundle, we get an excerpt from the shorter Oxford English Dictionary, which has something broadly along the same lines. Do you say that that is an appropriate definition of recreation?
Yes, a recreation is an activity or pastime pursued for the pleasure or interest it gives. And we know, which is why I declined to provide to the court any form of list of recreations, that it's as long and as varied as there are people in this country. And that is what it means. And the short point is that if one speaks about it, and as I've indicated at paragraph 17, if someone says, my recreation is camping rather than cricket, that's not a misuse of the language. And if the same individual says, I like camping because it's open air, gets me out, that also would not be a misuse of the language. And the skeleton argument goes on, paragraph 18, to indicate how these matters are recorded in a variety of places, including what His Majesty's government has to say about the matter, and detail being given of recreational visits involving wild camping and sleeping under the stars. And there are no doubt some who go off on their Duke of Edinburgh's expedition with a heavy heart, and some who go off anxious for it. But that is recreation that they are embarking upon. And as is apparent, there are public health advantages to open air recreation, which stands to be encouraged, not discouraged. And then at paragraph 20, and once again I'm going to refrain from taking the court to these references, which you will be able to see in any event. The National Parks Committee, recreation catered for by, amongst other things, camping sites. And you need to have ample provision for public open air enjoyment.
But might that mean something different? Might that not mean what the Chancellor had in mind in terms of a facility to allow recreation? So you go to your campsite, which may or may not be enjoyable, and you go from your campsite to walk on the moor.
Yes, I mean, there are going to be questions of fact and degree in terms of this, but I readily accept that one can suppose I'll use slightly different language if I may, my lord. One can readily suppose what I will describe for the purpose of answering the question as a holiday village. And the holiday village may consist of little more than glorified tents put together alongside some rather dubious washing facilities and so forth. And that might be a base for a family to embark upon their fortnight's holiday. And in those circumstances, it may very well be that the site I've just described, the holiday village, one wouldn't use for that the total label of open air recreation, although there might be bits within it, a tennis court for example, which undoubtedly would be. But there is a distinct contrast to the person who simply sets off and says, I want a night under the stars. I want to be refreshed by that night under the stars. I'm obviously going to take this tent with me because it's blowing up a gale or whatever it may be, but the recreation is still outdoors. But camping, he's got to put everything up, he's got to in and out of the tent and so forth. And so the point there is that there will be, at some point, a boundary to be explored over whether something is an open air recreation or something is my holiday village. But we are not concerned with the holiday village. We are concerned with the prospect of it being said that all camping is out with the expression outdoor recreation. And that is the proposition that I deny.
Just while we've distracted you, can I just ask you, going back to bylaws, one technical question, which I'm sure you will know the answer, probably everyone else in court knows the answer to, but I don't. Bylaw certainly criminalises certain activities. I'm interested in the civil rights of the person on whose land the activity prohibited by the bylaw occurs. So suppose someone did in fact camp on one of the areas of Schedule 2 to the bylaws. He could be prosecuted. Could the owner of that land, assuming wild camping was otherwise permitted by 10.1, say you are trespassing here because it's contrary to the bylaws and therefore I can evict you using reasonable force, or in an extreme case get an injunction against you? Or could the other person say, sorry, that's an injunction, that's injunction to enforce the criminal law, which you can do in certain circumstances, but the point is it doesn't make my being here a trespass.
Can I answer that question by supposing that the protagonists in your lordship's example have got a copy of section 10 and the bylaws to hand, and
You can answer it that way, but it's a simple question of law, isn't it? Which I just thought that probably all local authority lawyers are very familiar with. But i.e., effectively, can you bring civil proceedings on the basis that something's a breach of a bylaw?
well, the answer to that question is that if you've got a breach of the bylaw which results in the trespass, then you could. The reason
But
why,
does it result in it?
Yes, because that's why I was going back to section 10,
Oh, I see.
because subject to the provisions of this act and compliance with all rules,
Yes, I see. Well,
regulations
thank
and
you.
bylaws.
Sorry, I was over hasty.
No, that's why I wanted to get back to section 10, because the protagonists in your lordship's example, if the
Yeah, I see.
Yeah.
Okay, that seems to me a complete answer. I just hadn't thought it through, but you've given me the answer. Thank you.
but that is how it would go.
Thank you.
And so we get, I mean, the bylaws, I do respectfully say, is something of a side issue here. I appreciate that the Master of the Rolls is anxious about what does Rule 6 mean and so forth. But the real question is always going to be, what does that piece of primary legislation mean, Section 10?
So you put your entire argument due on that construction issue, and you no longer place any reliance on the fact that it was understood either from the bylaws or from any other extrinsic activity that camping was permitted.
Yes, I'm not pursuing the argument that was pursued below, which was based upon what Lord Carnworth had said in a particular case when he said that in construing legislation you can take account of what's been going on to arrive at a view as to what was the meaning of the legislation. I say that the meaning doesn't require that support to be given, and moreover, it's not necessarily the most satisfactory way to proceed, because all it did was elicit argument about the extent to which there had been camping, the extent to which people had complained about it, the extent to which people had been moved on. Better to consider the words and what they meant, and consider what was plainly intended given the recitals to the Act and the legislation being promoted by Devon County Council for the benefit of the public, because, as has been pointed out in our skeleton argument, I believe, the position is one whereby you have to construe private legislation in favour of the public and against the promoters, and furthermore, the position is one whereby this legislation does not operate in any shape or form as disproprietary as far as the owners are concerned, because we've seen that particular legislation and how we've got a provision which prevents any damage occurring.
But is it not still expropriatory or whatever to degree, in the sense that previously a landowner could have objected to somebody camping, and do you say they can't anymore, therefore they've lost a right that they had before?
Well, the position is one whereby if you say, have you been dispossessed of your possessions, the answer is no, you haven't been dispossessed of any possession, because the only thing that you can't do is now to sue someone for putting a tent without causing any...
Not sue, you could evict them. You can come along and say...
or evict, yes.
That's surely that's taking away a right. It's a right of exclusive enjoyment of your own land.
It's lessons, or may be thought to lessen the enjoyment of your own land, but on analysis, as far as this is concerned, I respectfully say it doesn't do any such thing, because the position is one's dealing with this common land.
Common land doesn't mean it doesn't belong to anyone.
No.
It just means that commoners have certain specific,
Commoners
well-recognised rights.
Commoners have rights.
We're not talking about the rights of the commoners at all here. We're talking about rights of people who aren't commoners.
Yeah.
The public generally. So
Yeah,
commoners is a red herring, isn't it?
No, it's not a red herring, because it helps to understand what the character is of the land with which we're concerned. So we're not concerned with 10 Acacia Gardens, we're concerned with Dartmoor, over which there are commoners' rights over this extensive piece of moorland, where whatever the position may be in terms of the precise legal basis for it, in the past, undoubtedly, there have been many visitors to Dartmoor without let or hindrance. And so therefore you have to say to yourself, are we really in the realms of removing some right of value, or is the case one whereby the land remains in the ownership of, as it does, and it remains unaffected by the activity as it does, subject to the regulation by the bylaws, which can be, of course, and are consulted about with the owners, amongst others, as to what you actually want.
So just to be clear, you say it's poor quality land which cannot be enclosed, therefore a landowner can't do much with it anyway.
Yeah, well, there's not much, because he's got, in any event, to think about the commoners' rights as well. So all I'm saying is that it's not correct to proceed upon the footing that one can say this land is to be treated as if one was appropriating by enfranchisement or otherwise one of the Duke of Westminster's properties. We're simply not there at all. And we are simply in the world where millions of people always have come onto the land. And you'll see the figures in that Hansard extract, and they are huge.
Could I ask a related question? I'm still trying to work out whether, it seems to be at the moment that the 1985 Act puts landowners to whom it applies in a worse position than landowners elsewhere in the national park. Because elsewhere in the national park, the rights of access in similar language to those of Section 10 only apply where you make an access agreement. Now, we haven't been given the provisions about access agreements, and I'm afraid not an area I know much about, but I'm assuming that a landowner can, in principle, refuse to make an access agreement. And even if they can't refuse, they can certainly make it subject to conditions. So,
well, I'm not sure you're right.
Well,
actually,
that's why I'm
because
asking to be educated.
access agreements or orders.
Yes.
So you can have an access order as well.
Yeah.
I don't know whether there are any.
Well, that's what I wondered. Is the structure that landowners within a national park and the park authority are encouraged to make access agreements, but if they can't, the park has a reserve agreement to make an access order? I have no idea. We haven't been shown the
No,
provisions.
you
so I want
haven't
you to
been
tell me.
shown, and I don't want to embark upon a lecture.
No, I
so
don't
to
want to
speak.
lecture. I just want to
No,
ask
where I
a
can't,
consensus.
where I feel myself unable to give an absolutely definitive answer, but it goes as the Master of the Rolls has indicated. But I would be prepared to accept that there can be a difference between the arrangements when one's seeking an agreement from the situation in Dartmoor when one's got the Act of Parliament, because I stand and fall, if you like, on the basis of the Act and what the Act
But
actually says.
what is the position in the rest of the national park that is not commons? Can you camp in the rest of the national park? No.
I'd have to come back to your Lordship on that to give an absolutely definitive answer. But as I say, I'm prepared to concede that there can be differences between when one's operating on an agreement or order and under the 1985 Act. But that doesn't lead to the conclusion that the 85 Act means something different from what it actually says.
So what's the essential? I mean, I get all that, but what's the essential difference between the commons part of the national park and the rest of the national park?
Well, the essential difference is that it's been brought into a regime, just as the other land is within a regime, which enables the outdoor recreation to occur. It's brought alongside, if you like, even though there may be some differences with the other land, because you see from the recitals that one's concerned with.
Well, I wonder whether the difference might be, mightn't it, Mr. Straker, that a scheme based on access agreements is not easy to make in the context of common land, because you are not concerned only with the interests of the owner of the land, but you're also concerned with the interests of the commoners. And I'm thinking aloud here, but I suspect that the reason why, the justification for having a different regime for land covered by the 1985 Act is that it is all, by definition, commons land. It was thought that it would be very difficult to make access agreements in that context. I don't know.
Yeah, but
I may be throwing you a lifeline, which is
whether it's a lifeline or not, because in my submission, one's got sufficient flotation through the terms of the Act in any event. But if you look at 023, where we are within the recitals to the Act, right at the top, we have precisely your Lordship's observation of the point. Some 2/5, 40% of the area of the park is registered as common land under the names of various commons pursuant to the Commons Registration Act 1965. And there are other common lands in the environs of the park also so registered, which are suitable for regulation in conjunction with the commons lying in the park. And so this was very much, let us deal with land which is common land, because not merely was there the point about the commoners, which I averted to for earlier, and the problems they had, but also the point of we've got all these commoners. It's quite difficult to identify precisely who they are at any given moment, but if we do it this way, then we bring into a regime which is regulated without harming anybody, and enables the public to be afforded a right of access. And the first three recitals on page 23 all support that proposition. My Lords, I'm anxious looking at the clock, because I know that my learned friend Mr. Honey would like 30 minutes subject to the court, and then I'm anxious to adhere to my Lord's observation about giving my learned friend some time, Mr. Moorhead's, before 1 o'clock. And so I rather contemplate, so to speak, taking everything else at pace or as read through the skeleton argument, which the court will have had an opportunity to see. But I do say that, with the greatest respect, it is patent that the words can't mean what my learned friend Mr. Moorhead signifies them as meaning. So if it's convenient to the court, that's the course I will take, if I may.
Yeah. Yes.
I'm much
Thank you,
obliged.
Mr. Straker. Mr. Honey.
My Lords, we say section 10.1 confers on the public a right of access to certain land, the Dartmoor Commons, by certain means, on foot and on horseback, for a certain purpose, open air recreation. On foot and on horseback is how the access is taken, the manner of entry, if I can put it like that, and those words do not limit the substance of the right. There are two main points we make to show that it is not just a right to roam, a right to walk or ride. The first of those is the second part of section 10. Section 10.1, which the court has already seen. But that shows, in my submission, the public's entitlement to be on the commons is not limited to roaming or walking or horse riding. A person is entitled to be on the commons for the purpose of open air recreation under that section 10 right, and for any activity that falls within that purpose which is not otherwise excluded. So that, we say, confirms our reading of the first part of section 10.1. But it also shows it's not just a right to be on the commons.
What do you mean by the second part?
So it's where it is after the semicolon, fifth line, and a person who enters for that purpose or who is on the commons for that purpose. So the section 10.1 right is an entitlement to be on the commons, not just for walking or horse riding, but for the purpose of open air recreation. So we say first that confirms our reading of that first part of section 10.1, But secondly, it makes clear that the entitlement to be on the commons is not just limited to roaming. The second point we make here is the need to read section 10.1 as a whole and give effect to all parts of it. And in my submission, construing section 10.1 as a right to roam does not give effect to the phrase for the purpose of open air recreation. And that is because in our submission, all walking and horse riding under the section 10 right on Dartmoor would in practice be recreational. The commoners have a right to access pursuant to their right of commons. So if anyone is invoking the section 10.1 right to walk or horse ride, in our submission it would be for the purposes of recreation, and therefore those words on the respondent's interpretation would be OTOs. And it's well established in my submission that the courts must seek an interpretation which gives effective meaning to all words in the statutory provision, which does not happen in my submission on the respondent's interpretation.
Well, you could have examples where people were riding not for recreation. Someone might say to their stable land, go out and exercise the horse on the common lands. It wouldn't really be for recreation, it'd be part of their job.
Well, I think that's why I've used the phrase, my lord, in practice, because it is always, of course, possible in theory to think of reasons.
Yeah.
But in terms of giving this effect in
Catch
practice,
almost everyone.
yes. So if that phrase does, it has, as it were, the approach of the respondent, then it does mean that that phrase is OTAs in practice. There are then two other parts of the Act that we refer to, which we say provide guidance on the meaning of section 10.1 and confirm the meaning we advance. The first of those is section 10.4b, which is towards the bottom of the page. And that is Roman 1, then under B. It refers to for the protection and restoration of the commons and their suitability for recreation. So this is about access being regulated or prohibited, but that is, in our submission, a statutory recognition of the commons' suitability as a place for recreation, not just for walking or horse riding. And there's a second provision in similar terms, which is section 4, subsection 1, which in the authorities bundle...
Sorry, say that again.
Subsection 4...
Of what?
Sorry, section 4, subsection 1 of this Act.
Yeah.
So in the authorities bundle, electronically it'll be 27. The bottom of the page we see section 4, duty of the Commoners' Council to take steps for the maintenance of the commons, and then over the page at the top, third line, the Commoners' Council shall have regard to, then if we read on, the commons and their use as a place of resort and recreation for enjoyment by the public. So that echoes section 10.4b and recognises the commons as a place for recreation by the public, not just for walking and horse riding. So those two statutory provisions, which say the commons are a place for recreation, in our submission confirms the meaning we advance. I'll then say something, if I may, about the bylaws. We do rely on the bylaws, paragraph 26 of our skeleton argument, as an aid to statutory interpretation under the rubric of contemporary exposition. What we have in the 1989 bylaws, made shortly after the Act came into force.
Sorry, when were the bylaws made?
1989.
So when did the Act come into force?
It was 1985, October 1985 was when the Act was passed.
So it's not all that contemporary, it's 4 years later.
But I thought it was 85, the bylaws. It says so.
They're 89. In our skeleton argument, my lord, we cite, I think, the case of Horgan, where regulations that were made 2 or 3 years after the passing of the main statute were taken into account as a contemporary exposition, and we say we fall within that.
So which is it, Horgan?
Horgan, I think from memory, my lord, yes. Hanlon, sorry, Hanlon, our footnote 11.
Oh, Hanlon and the Law Society.
Yes, that's right. Sorry. So we say these bylaws made shortly after the Act came into force.
Sorry, can we just get to the bottom of the date? So my lord thought it was 1985, but you say it's October 89, is that right? Or
It says 85 in the index to the legislation in the authorities bundle. Bylaws made. Oh, I see. Bylaws made under Dartmoor Commons Act 85. I took that as
Yeah,
the date.
it is 1989.
Where's the date? I can't see it in the document.
I'm just looking in our evidence.
oh, yeah, but the bylaws had to be published with the date.
So it's October 1989, and that date comes from our witness statement, which is supplementary bundle, page 86, paragraph 100.
That's Mr. Craddock. Isn't
It is, yes.
Which paragraph do you say?
Paragraph 100.
Do you know what happened in the interim? I mean, once the legislation had been passed in 1985, was it brought into force at once? Was there a gap before
I
there were any
don't. I
bylaws?
assume there would have been a gap, yes, whilst these matters were drawn up and.
But there would have been bylaws already under the 1949 Act, but they wouldn't have made express reference to the 1985 Act.
Yes, so we rely on the bylaws to show how the Act was understood at the time by the body responsible for the Act.
Yes, but what were the previous bylaws?
I can't assist, I'm afraid, my lord, on that.
Well, I mean, that's quite an important question, isn't it? I mean, the previous bylaws would have been, as my lord says, under Section 90 of the National Parks and Access to the Countryside Act 1949, and they would have been addressing the points in Section 60 and Section 90 of that Act, which are exactly the same points. So, what was it?
I can't assist, my lord, I'm afraid, on that particular question.
Right.
So, if I could ask
the judge wasn't told.
No. If I could ask the court to go to the bylaws, which is the authorities bundle, hard copy, page 58. The court has seen paragraph 1. I'll just ask the court, please, to look also at paragraph 2, which is the bottom of that page, under extent of bylaws, which says nothing in these bylaws shall apply to, and then over the page we see any act done by any person acting with the owner's consent. That's the second block of text. So the bylaws would not apply to camping with the owner's consent.
Or anything else.
The court has seen bylaw 6, which covers detailed controls on camping, unlike most of the other bylaws, which prohibit an activity. Here, camping, like kites in bylaw 18, are regulated in detail as to how it is to happen. So we say the bylaws assume that camping on the commons is permissible without the consent of the landowner, and they regulate it in detail as an activity, which in our submission is an indicator that camping on the commons was permitted by the Section 10 right. Now, if, as the respondent contends, the public must have the owner's consent in every case of camping, there would, in my submission, be no need to govern matters such as the location and duration of camping, because that would be covered by the consent obtained from the landowner when obtained it. So that's exactly the kind of thing that you would agree with a landowner when getting consent. And as to the respondent's point that the bylaws criminalise certain things, even if a camper has the owner's consent, that's not right, because the bylaws would not apply to camping where the owner's consent is obtained. And indeed, in my submission, it would be pointless anyway to try to control.
So whose point are you meeting now? I didn't understand that as a point.
Mr. Moore's head.
Oh, does he? Okay, I missed it. Okay, sorry, do go on.
So that's what I wanted to say about the bylaws. We say they support our interpretation. As to the scope of the Section 10 right and camping at least of some kinds, in my submission, is within the Section 10 right. We've covered recreation in our skeleton. I won't repeat that. but I'll just stress 3 points if I may. The first is the courts have considered the meaning of the term recreation in a commons context, in the case of Muir, which is paragraph 43 of our skeleton, and said that it has a broad meaning. Secondly, the Scottish legislation, which permits wild camping, is based on words which simply confer a right to be on land for recreational purposes.
How does the Scottish legislation help us?
We say that because it says that the concept of being on land for recreational purposes, and it's accepted there, that includes wild camping, that is comparable to the situation here, because Section 10 provides a right to be on land for recreational purposes. It is analogous, we say. The third point I make at this stage is that the judge below in paragraph 80 accepted that rock climbing was within the ambit of Section 10, but that's plainly not recreational walking. But if one accepts that rock climbing is within Section 10 for the reasons the judge gave in paragraph 80, then there's no basis for excluding wild camping. And the respondent's skeleton focuses on tents, but of course you can camp without a tent, especially when we're concerned with what's called wild camping. But the declaration that was granted governed not just pitching tents, but otherwise making camp overnight. So we're concerned with an order which goes beyond just pitching tents. And you don't need a tent to camp. You can sleep in the open air on a ground sheet, under a blanket. You can use a bivvy bag or a waterproof sleeping bag. You can sleep in a hammock or under a camping tarpaulin. And especially in the case of wild camping or backpack camping, which is what we're concerned about. But all of those things are caught by the declaration that was made. And all of those forms of camping overnight clearly would be open air recreation, whatever the answer to the debate about being inside a tent is. So my submission, even if the respondent is right about the use of tents, that wouldn't preclude other forms of wild camping overnight. We also make an additional point in paragraphs 48 to 50 of our skeleton argument, which is even if you take a narrower meaning of the right of recreation here just to be recreational walking, in my submission, before making a declaration, the court must still consider the practical scope of the right in connection with the declaration that's sought. Because the right must embrace, we say, everything that's part and parcel of recreational walking, as the right could be exercised in practice. And in our submission, it would be part and parcel of some long-distance walking to camp overnight along the route. That's backpack camping. Would be within the Section 10 right, even if it is narrowly construed as recreational walking. Now, in response to this, the respondent says that no part of Dartmoor is more than 5 miles from a public road. But that seems to assume that simply reaching a public road means there's no need for accommodation by camping, which in our submission is obviously very far from the case, because roads have, or Dartmoor, no or very limited public transport, as Mr. Craddock explains. You could still be miles or hours away from a place to sleep if you're not wild camping once you hit a road. And in any event, 5 miles is a fair distance to walk across terrain such as Dartmoor. And also, long distance walks, like the Two Moors Way, pass through Dartmoor. So you could be on Dartmoor at the end of a long day's walk. And in our submission, even narrowly construed, recreational walking would include some, at least, camping, what's referred to as backpack camping. So I've taken that quickly. I'd like also to deal with the expropriation argument, if I may. We cover this in our skeleton argument, paragraphs 56 to 66. And due to time, I'm going to take that as read, but I want to add some points, if I may, in response to how the respondent in their skeleton argument has dealt with this. So the first of those, in response to their paragraph 43, is that we don't accept that the words in section 10.1 are capable of bearing the meaning given to them by the Chancellor, because, as we've explained in paragraphs 17 to 18 of our skeleton, that does not give any effect to part of the statutory phrase. That's my OTO's point. But at this point, I'd invite the court just to stand back and bear in mind that the Act struck a balance between landowners, commoners and the public, attempting to deal with the interests of all. This is not a case simply of a new burden being imposed on a landowner. It was a careful balance struck by that Act of Parliament, and in my submission the court should respect that balance.
Can I just be clear about the balance? The balance really is that the landowner loses all rights to prevent any recreational activities on their land, provided it's not otherwise tortious, doesn't create a nuisance, and provided it is not prohibited by the bylaws. So really the power goes into the bylaws.
Well, in part, but there's also significant restrictions in the Act itself. That whole series of sections from 10 through to 14, the section 10.1 is about permitting access, but all the rest of it is about regulating the use, and that includes bylaws, of course.
Yes, but what, just remind me what the other provisions are. As you say, bylaws, but I haven't. And of course, built into 10 is that you mustn't effectively commit a nuisance.
Yes.
You mustn't damage.
So 10 includes, yes, as your lordship says, no damage, etc., as well as the other statutory controls that are referred to in there. Section 11 is bylaws.
Yep.
Then section 12 deals with giving directions to the use of tracks for horses. 13 is protection of commons.
Sorry, I'm going a bit too fast. I'm going a bit too fast. I'm going to do that.
So if we're in
Precisely,
the authorities bundle, you could just look from the side notes as to the titles of the particular sections. So there are a
Section
whole
13, it doesn't protect landowners, does it?
Well, there are elements. I mean, certainly when one has the protection of commons is to an extent for the benefits of landowners, because they'll be using it, as in this case, for grazing their animals, protection against damage and so on. But I make the point to say here that certainly one element is that those sections 10 to 14 are regulatory protections of one sort or another. We've also got the benefit to landowners through the establishment of the Commoners' Council to regulate commoners' rights.
But that's about commoners' rights. We're really talking about the rights of the landowners as against visitors who aren't commoners.
Well, the point I'm making, my lord, is that there's an overall package where a series of measures are put in place dealing with that triumvirate of rights, as it were, the landowners, the commoners and the public, seeking to come up with a statutory scheme to manage them. And we say, for example, that's comparable to the position with town and village greens, as described by Lord Hoffman in the Oxfordshire case, which we cite in our skeleton argument.
Mr. Honey, doesn't section 14 slightly provide a hurdle for you? It says, where a member of the public enters upon the commons for the purpose of open-air recreation on foot or on horseback and causes damage to the commons, it looks as if the purpose is open-air recreation on foot or on horseback.
Well, in our submission,
you say that it governs the term enters.
We say it shows that the substance of the right is access for the purpose of open-air recreation, and that being on foot or horseback is the means by which you access the commons. So that fits with our reading, especially taken with those sections, the parts of section 10 and section 4 I showed the court earlier, which recognise the commons as a place for recreation.
Unless the words on foot or horseback qualify open-air recreation.
Yes, I mean, we say that section 14, as we cited in our skeleton argument, supports us in terms of looking at things as a whole. Certainly,
I know you say that, but I'm just putting to you the opposing point of view.
Yes. No, I'd certainly, In a sense, we are here because there are two ways to approach it. We say that it's clear because of the way we approach section 10.1 and the need to give effect to all parts of it. It's not reasonable to give it the meaning that the respondents contend for, but I'm not about to suggest that everything points our way. What we say in relation...
Sorry, could I just ask you, while we're still on the question of the balance, which I think is what you're still talking about, you may, given your client's particular expertise, be better able to help than Mr. Straker on the question of what the scheme is for the rest of the park. Well, what I was putting to Mr. Straker was that the rights are largely governed or regulated by access agreements, which, if that's all there is, must by definition be voluntary. But as my lord pointed out, there's also reference to orders, or we haven't been shown what the scheme is. But do I infer correctly that the scheme is that there's a preference for parties making agreements, that's to say the Park Authority and the landowners making agreements, but that where they don't, there is a right to impose what might otherwise be an agreement by order?
I will take instructions on that over lunch, if I may. What we say in our skeleton argument is, but for this right of access under the 1985 Act, the land would have been caught by the access right under the Countryside and Rights of Way Act. So there would be a different access right that would apply to the Dartmoor Commons.
Sorry, under the what? Under the 2000 Act?
Yes.
Right, I'm not trying to pick that up. Don't take us to it. What's the paragraph in your skeleton?
So it's towards the end. It is footnote 35.
Oh, that's why I didn't pick it up.
But that obviously wouldn't have been the case in 1985.
No, that's right.
No, so back in 1935, this is effectively a scheme presumably back in 1985 there was the possibility to make access agreements because it was within the national park, but for reasons which I speculated about, that obviously wasn't thought to be good enough, and this different scheme was put in place, perhaps because it's common land and has different characteristics.
Yes, that's the point we make, which is that we're dealing here with special land, the Dartmoor Commons, where there are landowners and the public, but also commoners.
Yes, no, well that makes perfectly good sense, but I would still quite like to know what the position is under the regime that would otherwise apply.
I'll take instructions to assist.
Possibly by way of amplification of that, I see the judge explains that the Commons comprise 75% of the moorland. So there must be 25% of the moorland that is not within this regime. And if it's possible to say more about how that works, I'd be interested.
I'll seek to assist if I can, take instructions over lunch. So the point is that when we're talking about expropriation, we're in the territory as per Lord Hoffman, paragraph 53 of Oxfordshire, where it's the control over land, the regulation of land, in the overall public interest, balancing a series of rights. And we're not, therefore, as it were, straight in the territory of expropriation, as has been suggested. It's also, I think, important to recognise that the things that are complained about in terms of the impact of camping would not be within the scope of the Section 10 right anyway, because that excludes activities which cause damage. So the things that cause damage are not any recreational activities under Section 10, because by definition they would be outside the scope of Section 10.
But you're probably right, but if you just leave litter everywhere, and unpleasant litter at that, why is that not within the purpose of Section 10?
Because Section 10 refers to without breaking or damaging any wall, fence, hedge, gate, or any other thing.
Yes, well, leaving litter doesn't fall within any of those, does it?
Well, I would, if it is the way it's been described, I would say that would fall within damaging.
Well, it's in
the
Schedule
land.
2 anyway.
Yes.
So Schedule 2 of the Master Act, really, expressly refers, if I remember rightly, Schedule 2, page 21 in the bundle says,
So K refers to deposits any rubbish or leaves any litter.
leaves any litter, K, 1K. So
Yeah.
this says that you don't get your exemption from trespassing if you're lighting fires, riding a vehicle,
Yes.
having a dog.
And the final point,
Not under control.
Yeah, well, there you go. That makes sense.
and the final point just to make under this heading, is that the respondents say they want wild camping to continue, but by licence. And therefore that demonstrates in my submission that wild camping itself cannot therefore in truth be problematic, so that it's not inherently that imposition. Now I'm going to pass over, if I may, to my junior Mr Westway, who's just going to deal very briefly with the other legislation points that we make in our skeleton argument. So we'll just use the final element of our time, if I may, to do that.
I'm grateful. I just intend to spend a few minutes covering the wider statutory context and the implications of that. I may not get through everything for your note. It's paragraphs 28 to 42 and 51 to 55 of our skeleton argument. The basic point that we make is that to understand the meaning and the effect of this provision, section 10, it's important to take into account the previous law, the evolution, and to some extent also the way that the law evolved. If I can attempt succinctly to address a question that arose as to the wider picture, both in Dartmoor, clearly
Which
the wider picture
paragraph in
is
your
also
skeleton?
a national one.
Which paragraph in your skeleton are we looking at?
I want to deal with a preliminary point first, and if I can direct the court's attention to section 15 of the 2000 Act, that was the one that was just referred to, that's page 86 of the authorities bundle. As far as other land is concerned, we know that section 10 relates...
So, where do I find the 2000 Act?
So the 2000 Act's behind tab 9, page 86 is where I want to go.
Thank you.
In very brief terms, what the 2000 Act does is it granted a wider right of access for recreation to other land. And section 15, which is where I've landed, is where one understands how that right, the wider right of access to open country, etc., under the 2000 Act, associates with other access rights. And it's significant in my submission that they're all treated together. So we have a species of law that's creating public access rights, and one finds here, for example, section 193 of the Law of Property Act that we refer to in our skeleton is carved out, that's not covered by 2000. Then subsection B, nor is Local or Private Act, so that's the Dartmoor Commons Act, and that links to footnote 35 of our skeleton, because had it not been for the Dartmoor Commons Act, these commons, as commons, would all be covered by the 2000 Act. And then looking down, one can see then a reference to another familiar provision, part 5 of the 1949 Act, a little c. And broadly, the position is that we have a substantial area of Dartmoor, we're just looking at Dartmoor, that's covered by the Dartmoor Commons Act, but clearly there's other bits of Dartmoor too. Some of those will be open country, covered by the 2000 Act, and we refer to one particular area of open country called High House Waste in our skeleton argument, where camping is allowed, has been allowed under the 2000 Act. One of the viewpoints I want to make, I'll come to that.
How does this fit in, though? This is all something that happened subsequent to the passing of the Act, so it can't...
That happened subsequently, but the way in which these open access rights, the public access rights, have been granted to the public over time, going back to the 19th century, has been consistent. There is a consistent pattern in my submission of granting wide access rights to the public and then derogating from them if one likes, or creating exceptions to them through specific restrictions. And that, in my submission, bears upon how one should look at the specific provision in section 10. So it both antedates and then postdates section 10, but it's the same pattern, and it's interesting to find Parliament identifying the package of access rights in section 15 altogether, and in my submission that's a correct approach. So that's really the first sort of overarching submission. The second one is, as we make in our skeleton, I won't labour this is there are implications, therefore, for how one interprets Section 10 or how other provisions might be interpreted. My Lords, Mr. Craddock, in his witness statement, which I won't go through, he sets out in some detail the background to all of this. All I would say is two things, is that one notes the terminology varies, so what may be described as a privilege or an immunity, and we see that in Section 60, so will not be taken for action in trespass, becomes expressed as a right in later legislation, but it's all the same. You know, these are effectively rights granted. The second one is that the words used, air, exercise, recreation, open air recreation, vary in their combinations, but again, they're all effectively the same thing in my submission, and it wouldn't be appropriate to take, for example, air and exercise narrowly and open air recreation broadly, or vice versa. They should all be construed broadly. There's a lot here, and I want to focus on 3 points only in the time I have, as briefly as I can. The first is Section 193. So this is the 1925 Act, and there will be bits of Dartmoor that are not common that might be covered by Section 193. I don't think we know the exact extent of them, but this is a context that would apply nationally and also to Dartmoor. It's in the Authorities Bundle, tab 1, page 3. And in my submission, this is significant for 2 reasons. One, because it's the only example of the general right of access that we have being granted directly by statute prior to the 1985 Act. And secondly, because it's the only example where there's been some judicial consideration of a public access right.
Sorry, why are you excluding the 1949 Act?
The 1949 Act depends upon further implementation. So
I see. No, I've got it.
It depends upon an order or an agreement. I will come to 1949.
No, that's fine. That's what I want to know.
But clearly, 1925 Act was quite significant for the 1949 Act as well. I mean, they are a continuum in terms of the development of the law.
But I mean, 193 is in much more restricted terms, isn't it?
In my submission, it shows the same basic structure, and one could see that in terms of have rights of access, then for air and exercise. So the distinction between the rights to access and then effectively the purpose for which they're exercised. It's more restricted because its application is to metropolitan commons effectively.
But also it's only air and exercise. Camping might be out with air and exercise even if it's within recreation.
Well, here's where, in my submission, one can find an answer in Section 1931, because at Section 1931, little c, one finds the qualifications to the exercise of the right for air and exercise, and it's little c, my Lord will see, provided that the access shall not include rights to or drive on the land, etc., or to camp or light a fire. And in my submission, that's a clear indication that this right of access was considered in principle to include a right to camp, and that's been excluded from it.
Well, you often get this in drafting. A lot is put in for the avoidance of doubt without always using that phrase.
Well, my submission is supportive of authority, and in the interest of time, if I could just go to that authority. That's the ex parte Bilson case, which is at tab 19 in the authorities bundle. So the case itself was a challenge to a defensive map modification order. So it starts on page 355. In this case, it wasn't one of these metropolitan cases. It was a case where Section 193 applied because of a deed that had been made under it, but it was still the same provision. And the issue in the case arose as to whether the right included the taking of air and exercise whilst horse riding. And Mr. Justice Sullivan concluded that it did. The key references, for my purposes, in in the bundle, page 372, maybe 373 of the PDF. And it's between E and F, the conclusions, and Mr. Sullivan cut straight to the chase, and the first issue he addresses is what's the scope, effectively, of section 193. And I draw attention to the words just between F and G in the first
What's the page in the law report? 391.
391.
At H.
At 391 F to G.
F to G, oh, sorry.
And in my submission, that approach, broadest possible rights of access, is of general application and should be taken to apply also to section 10. The second point, my lords, is how the proviso, so we saw that proviso at C that referred to camping, how that proviso was then taken by the judge, and if the court can look over, so going down to H now and reading over to 392 A to B, because the proviso refers to effectively horses, the judge finds that it would be otiose to include that particular provision there if the public were not allowed to bring horses onto the common. And in my submission, that reasoning applies a fortiori to camping, which is expressly referred to in subsection C. So that's the first part of the context, and there will be bits of the common where that applies. Clearly, where that applies, there won't be camping because of subsection C. But that's
And you
not
could, I
because-
suppose, make this point, that perhaps this is the point you're making, but that the draftsman of the 1985 Act would certainly have been aware of section 193 and was aware that although it didn't use the language of outdoor recreation, it did use language which you would say to the same effect, and thought it necessary or at least prudent to exclude a right to camp, but didn't do that themselves.
Yes, and this is the evolution of the terminology. It changes from air and exercise to open air recreation, but it's effectively the same thing in my submission. The second point I want to make is related to the 1949 Act that's come up a couple of times. That's in tab 2, and we've looked at section 60, which is the key provision for my purposes, although we've noticed schedule 2 as well.
Lord, I ought to register an objection to the court that's now been taken. The intervention was permitted on the basis of a maximum of 30 minutes of oral submissions. That time has long been exceeded. I was not expecting a second counsel to address the court. That was brought on us afresh. We're now also corroding the time which it is necessary for me fairly to respond to the points which have already been made in view of extensive written submissions.
Yes, let's Mr. Westaway finish briefly this point on the 49 Act. Very briefly, Mr. Westaway, you have slightly overstepped the mark with two counsel addressing the court as an intervener. Not your fault.
I will be as brief as I can.
Well, you'll be very brief.
Yes, which is
2 minutes.
So under section 60, 2 points. It's the same formulation as found under section 10. That's already been observed. There are restrictions on the exercise of the right. They're contained in the statute itself to not damage fences. They can also be contained in agreements or orders, and they can be contained in bylaws. The one sees that from the Act, and the witness statement of Mr. Craddock gives examples of numerous agreements made under section 60. He says only 2 orders were ever made, but numerous agreements that excluded camping. And that's a clear indication in our submission that camping was considered to come within the scope of the right, very similarly expressed right. Otherwise, there'd be no need to exclude it.
What's the reference to page number to Mr. Craddock?
To Mr. Craddock. The addresses the 1949 Act and agreements. Apparently, so it's supplementary bundle page 77 through to 81.
What are the para numbers?
Para 63 and following. The specific reference to where he's reviewed the agreements is para 71.
Okay.
So that, in very summary terms, is the point on section 60. In terms of the 2000 Act, I've already covered that. I make the same point. Effectively, that should be read in the same way, and I just want to draw one final point to the Court's attention. This is the slightly broader way in which the changes in the 2000 Act were anticipated, and
Lord, I'll repeat my objection. Either this is in the skeleton argument, in which case it is a point which must now be taken as read, or it's not, in which case it's a point which should not now be made.
it's certainly a point in the skeleton argument.
Well, then that's sufficient.
Just tell us where it's in the skeleton. We don't need to get into it now. Mr. Westaway.
Yes. So it's paras 38, 39 and 40. I'd ask the Court in particular to look at paras 39 and 40 relating to the full expression of the right of open-air access under the 2000 Act, where the basic point is that full expression includes camping for the reasons set out there.
Okay. Thank you, Mr. Westaway.
Grateful.
Yes, Mr. Worshead.
May it please your Lordships, we're told by the Supreme Court that the primary source of meaning when considering any instrument, including statute, is the analysis of the language used. And the Chancellor below quoted the most authoritative recent statement of that principle in paragraph 16. Lord Hodge, in the, I think it's in the Coughlin case, it's from the Children's British Citizens case, the primary source by which meaning is ascertained is by way of conducting an analysis of the language used by Parliament. I have been waiting to hear an exercise in the analysis of section 10.1 of the 1985 Act, and we have not heard it. So I would like to start by doing that exercise with your Lordship.
I have to say, I thought we had an analysis. I thought that the analysis was that there's a right to be, or go on to, or be on the commons for the purpose of open-air recreation. We've been told something about what open-air recreation is said to mean, and we've been told that on foot and on horseback relates to the means by which you get there. Is that not an analysis?
Well, my suggestion is that that's a correct analysis, is that that is a statement of the conclusions which the appellant and the OSS desire to achieve from the language, but without actually analysing the language. I don't want to get hung up.
You analyse the language, Mr. Morshead, and we'll hear your submissions.
I don't want to get too hung up on whether there has been an analysis or not. My point is that we have to start with the language and analyse what the words say.
Yeah.
And I've made the overall point in paragraphs 14 to 21 of my skeleton argument, which I'd like to develop. But I say as an initial point, again, I may have missed it, but I haven't detected an answer to the analysis that is there set out.
Can you explain to me why, in words of one syllable would help me, why, when this statute gives a right of access to the commons on foot and on horseback for the purposes of open-air recreation, the right is not a right of access for the purpose of open-air recreation, and the means of access is foot or horseback as opposed to car, say.
Yes, and
why is that wrong?
I'm going to explain to you.
Yes.
the way to examine this is by going to the text itself. What the public gets is a right of access to the commons on foot and on horseback for the purpose of open air recreation. My first point is that that is not the same as a right to enter the commons on foot or on horseback, to use the commons for recreational purposes. Neither is it a right, just looking at the language, by contrast, it's not a right to enter on and use and occupy the commons for recreation or other purposes. So this is the
So
point.
you say on foot and on horseback qualifies right of access. So in other words, the right of access is only on foot or on horseback, and that's obviously correct.
Yes.
But why is the right not a right of access on foot and on horseback? In other words, you can only go in there on foot and horseback for the purposes of open air recreation, whatever that means.
Oh, well, the first point to notice in point of detail on that is the use of the word purpose rather than purposes.
Yes.
And that is by contrast with some of the examples that Mr. Craddock has found. For example, the Abbotside formulation, which is the earliest example of this, in supplemental bundle page 90. Reference has been made to the legislative, earlier legislative history. I don't accept that there's very much to be learned, but points of contrast are perhaps illuminated. Page 90. In this table is the example given, does your lordship have, third row down, one of the acts made to regulate access under the Commons Act 1976, privilege of playing games and of enjoying other species of recreation on Stag's Fell Plan. The use of the plural in that expression stands by way of notable contrast with the singular in our case.
Sorry, where's the plural?
Species. Species of recreation. Different kinds of recreation.
But surely purpose of recreation means purpose of any kind of recreation.
It may mean that, but let's read on and see whether...
Okay, I think we're going to break now because it's 1 o'clock, but we'll hold that thought until 2 o'clock. Thank you.
Report back.